Chapter 5 of the Patents Act 1970 talks about opposition proceedings to the grant of the patent. As per Section 25, there are two types of oppositions. First is pre-grant opposition and the other is post-grant opposition. Section 25 subclause 1 talks about pre-grant opposition, which is to be filed soon after the patent is published in the official journal and before the grant of the patent. Section 25 clause 2 states that if any opponent wishes to file the opposition to the patent after the grant of the patent, then he may do so, but that should be done within 1 year of the grant of the patent. Grounds of opposition of a patent. Section 25 subclause 1 and Section 25 subclause 2 defines more or less similar grounds for the opposition of a patent, one being pre-grant opposition and other being post-grant opposition. The first ground of opposition which both the subsections claim is that the applicant has wrongfully obtained the invention. In cases of wrongful obtainment of the invention, an opponent can lay a claim over the patent, and if he succeeds, then the patent will get revoked. At the same time, there are provisions in which the patent office can treat the patent of the applicant as patent of the opponent. Secondly, where a complete specification has already been published before the priority date of the application, then it will become a ground of opposition. A patent or an invention has to be kept secret till the filing of the patent application, that is, before obtaining the priority, it must not be disclosed to the public at large. If it has been published anywhere in the world, then it will become a ground of opposition. Third, if the claimed invention has been publicly known or publicly used in India before the priority date, then it will again be a ground of opposition. We can see that the point number 2 and point number 3 both talks about disclosure of the invention before the priority date. So if any invention has been disclosed before the priority date, then it will definitely be a ground of opposition. The fourth point, that the claimed invention does not contain an inventive step. We all know that among the three necessities of a patent, one of them is the inventive step. So if an invention does not disclose an inventive step, then it will become a ground of opposition. Fifth point, if the invention is not within the meaning of this act, then it is again a ground of opposition. For a patent to be granted, an invention should satisfy the three necessities as enshrined in Section 21J. That are, it should contain an inventive step, it should be capable of industrial application, and it should be novel. If any of these steps is missing, then it will not be considered as an invention within the meaning of this act. Sixth point talks about complete specification does not completely or sufficiently describe the invention or method by which it is to be performed. We have already discussed that the patent should be such that a person skilled in the art should re-engineer the whole invention just by reading that patent. If a complete specification does not completely discloses the best method of performing, then it will be a ground for opposition. 7th point states that if the applicant fails to furnish or provides wrong information under Section 8 of the Act, then it is again a ground of opposition. Section 8 of the Act prescribes that an applicant has to furnish all the details of the foreign filings, whether he has already filed an application in a foreign jurisdiction or whether he intends to file an application in a foreign jurisdiction. All those details have to be supplied within Section 8 during the time of application. Ground 8 of the opposition of the patent is the traditional knowledge. If any of the invention claimed is a traditional knowledge, then it will not be granted protection. Ground 9 to the opposition of the patents relate to filing of the application in convention countries. If an applicant fails to file an application in Indian Patent Office within 12 months of filing in a convention country, then this becomes a ground of opposition of the patent. The 10th ground of opposition to the patent is failure to disclose the actual source of biological material obtained to make an invention. We all know while filing of the patent applications pertaining to those inventions which are related to biology or which relates to biological material, we need to disclose the actual source of the material and from where it is obtained. Failure to do so will make it a ground of opposition to the patents. The various steps taken during patent opposition are as follows. The opponent files a patent opposition with the controller. As soon as the controller receives the patent opposition, he intimates the patent by way of a notice, and at the same time he constitutes a opposition board which would examine and give recommendations over the opposition. On recommendations of the opposition board, the controller conducts hearing and gives both the patentee and the opponent a fair chance to hear. If the opposition succeeds, then the controller may direct the patentee or the applicant to either revoke or amend the patent. If the opposition fails, then the patent application or patent continues to be in force. In our next video, we will be looking at the grounds for revocation of the patent, which are enshrined in Section 64. In the meantime, don't forget to like, subscribe, and share this channel. If you have any questions or any comments, then please drop them in the comment section below. Thank you.